Good morning, everyone.
Good morning.
My name is Mary Bonauto. I'm an attorney at Gay and Lesbian Advocates and Defenders, which is based in Boston. And you are soon going to hear from and meet all of these folks. Before I go any further, let me just say that we also, in addition to these extraordinary plaintiffs, we also have some lawyers here who are working on this case. And from GLAD, we have Jansen Wu, Liz Meyerbrother, Ashley Dunn, from Horton, Shields, and Knox here in Hartford. We have Karen Dowd. Not with us today are attorneys in D.C. from Jenner and Block. And in Boston, our tax counsel, Sullivan and Worcester. For those of you who don't know GLAD, Gay and Lesbian Advocates and Defenders, we're a legal organization in our 32nd year fighting for the rights of lesbian, gay, bisexual, and transgender people and people with HIV in the 6 New England states. Our lawsuits, among other things over these years, have resulted in marriage in Connecticut and Massachusetts. So we're here today because the time has come to challenge a discriminatory federal law right here in Connecticut. That is a law that was designed to, and in fact has harmed, gay and lesbian couples who join in marriage, and that law is Section 3 of the 1996 Defense of Marriage Act, otherwise known as DOMA. We filed a lawsuit this morning in federal district court here in Connecticut on behalf of these married couples and one widower, all of whom are legally married and recognized as such in their home states of Connecticut, Vermont, and New Hampshire. Section 3 of DOMA is a federal definition of marriage that is applied to all federal laws and programs by defining marriage and spouse as including different sex married couples only. DOMA refuses even to recognize the lawful marriages of these people. As a result, across the board and in every single federal program, DOMA operates to require the federal government to deny all federal rights, protections, and responsibilities associated with marriage only to married same-sex couples. And of course, these are protections that are routinely and readily available to all other married couples. In this case, the Pedersen Meitzen family right here and the Arden DeForge family right here are seeking family health insurance that covers their spouses just as their fellow federal employees and retirees may cover their spouses. But Joanne Pedersen, who is married to Anne, and Linda, who's married to Raquel, have been told that the federal government does not recognize same-sex marriages. And of course, because of DOMA, that is true. And ironically, Linda and Raquel both actually have individual policies through the government, but the government refuses to let them be on one family plan as the family that they are. Jerry Passaro is a widower, right here. He's a widower who is seeking Social Security benefits after the devastating loss of his partner and then spouse of 13 years last year. Under federal pension laws, Jerry would also have been able to rely on the survivor benefit from his deceased spouse's pension. But that also has been denied to him only because of DOMA. Another couple who could not be here today, Joe Marquis and Jan Geller from New Hampshire, spent decades as public school teachers in New Hampshire and are simply seeking the same retirement benefits that all of their colleagues have. But because of DOMA, they have been denied a medical cost subsidy that would save them $375 a month on health insurance. And that's a lot of money for 2 retired teachers. In addition to seeking a family health insurance policy, Linda and Raquel also need and want access to family medical leave. What is more basic than knowing that you don't have to choose between your job and your spouse and being able to take care of your spouse in a time of need? 2 other examples. Both Suzanne and Geraldine Hardis and 2 of their children. They have 3 children, and Brad Kleinerman and Flint Gary are couples here in Connecticut, and they have been paying extra federal income taxes because the federal government does not respect their marriage. They cannot use the correct filing status as married and have to pretend that they are either single or a head of household. And obviously, in both instances, Both of these families are raising 3 sons. This is money that they could put to good use. So the discrimination takes a toll on all of these folks. And DOMA effectively means that they cannot take better care of themselves, each other, and their children. Now, what does our suit argue? Our suit argues that DOMA violates the federal government's promise of equal protection of the laws that's contained in the Fifth Amendment of the United States Constitution. There is no reason, in our view, for the federal government to take one group of married people only and treat them differently from every other married person in any of these states. And let us also remember that it is states that marry people, not the federal government. DOMA is the only federal law in our nation's entire history that puts the federal government in a marriage business, a business governed by states. And for the first time ever, DOMA requires the federal government to refuse to recognize a whole class of state licensed marriages. Before DOMA, for our nation's entire history, the United States and later federal agencies accepted a state's determination that a couple is married. But back in 1996, when it looked like same-sex couples might soon be able to marry in Hawaii, the Congress changed the rules, and for all the wrong reasons. This suit seeks a declaration that DOMA violates the Equal Protection Guarantee and therefore cannot be constitutionally applied to these plaintiffs and in these programs: Social Security, federal income taxation, federal employee and retiree benefits, federal pension laws, and state retirement laws insofar as they're regulated by the federal government, and of course family medical leave. Now, some of you may know that this is not the first DOMA case that GLAAD has brought. We also represent Massachusetts couples in a case called Gill versus Office of Personnel Management, in which a federal district court judge this past summer ruled that DOMA is unconstitutional in that case. It's on appeal, and since we filed that case, which we filed back in March of '09, more states have enacted marriage laws. And it was obviously here in November of '08, but we filed that case in March of '09. And what we have found is more people have been married in Connecticut, in New Hampshire, in Vermont, is that DOMA sort of operates as a time bomb. So couples are very happy, they celebrate their marriages, and that's certainly understandable. But then months or years later, DOMA goes off or blows up, and they find that they have been denied some critical part of the safety net that is there for all other married couples. And that's wrong, and that's what this lawsuit is here to change today.